Legal Words for Interpreters Criminal Law. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. I'm here today with Helen Shaw, who is a Senior Solicitor in the Legal Aid New South Wales Criminal Indictable section. Good morning, Helen.
Good morning, and good morning, everybody.
We've just had an audience member saying their screen doesn't work. I'll just let the audience know that there are some options on your control panel to check if things aren't working. The other option is that you can join on you can dial in using a telephone and then just use your device to view the webinar, but the PowerPoint. But at the moment, from our end, it looks as if the screen is sharing with everybody.
Yes, I can see the slides. I can see it.
There is some help in the registration email that you would have received, so perhaps have a look there and in your control panel and see if you can fix things so that you can view the presentation. However, we will send a copy to people at the end. Before we begin the webinar proper, we would like to acknowledge the traditional owners of this land. We also would like to pay our respect to elders, past and present, and extend that respect to any Aboriginal or Torres Strait Islander people attending today or watching the recording. The purpose of the webinar is to explore common words used in criminal law settings. We have other webinars focusing on family and civil law words, which will run later in the year. So now I'll hand over to Helen and ask you to introduce yourself to our audience.
Thank you, Bridget, and good morning, everybody. I'm a solicitor, criminal law solicitor at Legal Aid in Sydney office of Legal Aid. We have many offices around the state, and I go to court in the local court, district court and Supreme Court, and my work involves engaging interpreters and translators very frequently in many different languages. So some of you may have been engaged by me and participated in a conference, assisted me to communicate with my client, or you may have seen me at court. Or if you do see me at court in the future, please say hello. And I just wanted to say that your work as interpreters is extremely important to enable me as a lawyer to communicate with my client. So thank you for the difficult job that you do, and it's such an important role in facilitating communication and helping other people understand each other in the court or during conferences. And I've been doing criminal law since 1998, so a long time, perhaps too long, but yeah. So I'm here to answer questions as well as explaining these words, and hopefully you'll get something positive out of it.
Thanks, Helen. I'll just go over for our participants what we will cover during the webinar today. We're going to cover common words used in courts, criminal process words, legal document words, words used in criminal law, words about offences, types of sentences, and where to get help with legal words. Okay, as we've said, today's focus is to assist people who interpret in criminal law settings. I'll hand over, or perhaps I'll run through this one, Helen, because then we've got a poll, and then I'll hand over to you after this slide.
Thank you.
Criminal law is the largest part of legal aid work and the largest section of Legal Aid New South Wales. The criminal lawyers at Legal Aid assist people charged with criminal offences appearing before the courts. We also have some specialist services, including the Children's Legal Service and Youth Hotline. Today we will just be talking about adult criminal law though. If you interpret for young people in the Children's Court, there are some differences. There's also the Drug Court and Prisoners Legal Service. We're interested to know about your experience in interpreting in criminal law settings. So we're just going to run a quick poll with you. You can answer this using your keyboard and choosing an option or typing into your question panel. I'll just open the poll now. So the question is, how much experience do you have interpreting in criminal law cases? So you can either answer the question on the screen, or if you're having trouble with that, then feel free to type into the question box. And welcome, Maria. I'm glad that you've managed to enter your message into the question box. Thank you for doing that. Okay, we'll just close off the poll now and share the results.
Yeah, quite a mix there, a mix of responses, so that's great. And hopefully, even for those that know quite a lot, hopefully there'll still be something for you to learn from this webinar. And for people that don't have any experience yet but are interested, great. I think you've come to the right place. And again, if you have any questions, we're here to answer those.
Okay, I'll hand over to you now, Helen, so we can start the webinar proper.
Thank you. So each matter in the court starts in the local court. So when police charge a person, whichever crime it is, whichever allegation, it will always start in the local court. And that's New South Wales, so different states may have a different name for it, like county court, different name, but in New South Wales, our first court is called the local court. And then some matters go up to district court, for example, robbery, sexual assault, some more serious violence offences will go to district court. Things like murder, terrorism, or a large tax fraud might go to Supreme Court. And if somebody appeals their conviction or the length of their sentence from district court or Supreme Court, then they have to go to the Court of Criminal Appeal, which is a division of the Supreme Court as well, and in the same building as the Supreme Court in Sydney. And then the highest court in Australia is the High Court of Australia, which is a federal court, and it takes appeals from all the states and territories, but only deals with a very few matters each year. And you need very special permission to even have your matter heard in the High Court, but it takes matters from every state and territory. And probably I think about 98% of matters finish in the local court. So from beginning to end, police will arrest somebody, and then police may choose to charge somebody, which starting the process of the allegations going to court. Police can choose to give somebody bail at the police station after they have been charged or not. If police do give somebody bail, then the person will be given a court date to attend the local court for the first time and have conditions, example, reporting to the police, being of good behaviour until their next court date. If police choose to refuse bail at the police station after they have charged the person with an offence, then the police must take the person to the local court, and at the local court the person may choose to make an application for bail from the local court magistrate. The magistrate can either give them bail or refuse bail. And after all the documents have been received and the police have served statements and different evidence, the person must decide on what they are going to do about their charge. That is, plead guilty or not guilty. They enter a plea. And if they plead not guilty, then they'll go to trial in the district court or Supreme Court, depending on what their charge is, or they may have their hearing in the local court by the magistrate and defend the charge. Or if a person pleads guilty, then they get sentenced by the court. They can be sentenced in the local court if their case stays in the local court, or they might have to go up to the higher court and be sentenced by a judge in the district court, or for murder matters or terrorism, go to the Supreme Court to be sentenced. So that's just a brief overview of the criminal process from arrest through to completion at either trial or sentence. So going back to the very beginning, somebody is arrested by police. So police, the job of police is to investigate charges, investigate people, investigate suspects. And police can bring somebody in, bring a suspect into the police station and ask them if they want to participate in an interview with police. For a person who needs an interpreter, the police should call an interpreter to come to the police station. Or as an interpreter, you may also receive a phone call asking you to translate a document. Police might send you a document about the accused person's rights, right to silence, right to speak to a lawyer, right to communicate with a friend, for example. So you may also have to do some interpreting or translation of a document that the police have given to a person. You may have to do that over the telephone, or you may have to do it in the police station. And you may also be required to interpret during the interview with the suspect, and that is video recorded and audio recorded and can be played in court if the person goes to trial. At the police station, you'll have the police officer, and some people may also have a lawyer at the police station with them. Or as the interpreter, you might be asked to interpret in a conversation between the client and their lawyer. The lawyer might be asked by police to speak to the client and explain their legal rights about the right to silence, or a forensic procedure, for example, DNA sample, and you as the interpreter may need to interpret what the lawyer is advising their client, or interpret what the police are explaining to the client about the DNA procedure or their right to silence. And a special caution happens when a person has a lawyer with them at the police station. So yes, they have a right to silence, but if they choose to give an interview with their lawyer present, then they are given an extra special caution by police that if you don't say something now which you wish to say later in court as part of your defence, it may be you may not be allowed to do that. So it's very important that the person understands that if they have their lawyer with them in the police station doing an interview, then they may have to give all the information now, otherwise risk not being able to raise something as part of their defence later. The term ERISP, or E-R-I-S-P, is an acronym standing for Electronic Record of Interview with Suspect or Suspected Person. That's what it stands for. Record of Interview, R-O-I, Record of Interview. They're essentially pretty much the same thing. It's a video and audio recording of the interview with police. And then we have a COPS, C-O-P-S. It's a database that police use, and they type up information about an investigation. And when somebody is spoken to by police, arrested by police, when police attend on the scene, the police type up a document, and every incident or event is given a number, a special number, and that's in the computer system used by police. H number, you'll hear this in the local court all the time. In particular, you'll hear magistrates or prosecutors or defence lawyers talking about H number, and that is a number, a reference number, which is on the police documentation. So every charge, every fact sheet will have an H number, and it's just a police reference number. It's several digits, several numbers, and every case will have a number. So when police charge somebody, the charges will have a specific reference number. So you'll often hear the court, especially if the person has more than one set of criminal charges, they might have 3 lots of paperwork, 3 lots of different charges, and the magistrate might, just to be clear, say, look, I'm looking at H number ending in the numbers 385, for example. So then the lawyers will have several pieces of paperwork just to make sure that they're all looking at the same document, because somebody might have been arrested 3 separate times, and the court will want to make sure that we're talking about the same arrest, the same piece of paper. So that's what H number is. It's a number that the police system gives to the set of charges. And on that topic, you've got sequence. Somebody might be arrested and charged with 5 separate offences under the one H number. So for example, I might have a robbery charge, an assault charge. I might resist arrest when I'm arrested by police, and I might damage some property. And so those 4 charges will have a different number, 1, 2, 3, 4. So they're separate charges under the one arrest, or the one H number, and they're called sequence 1, sequence 2, sequence 3, sequence 4. And in court, you might hear the lawyers say that my client is pleading guilty to sequence 2 and sequence 4, and the prosecution is going to withdraw sequence 1 and sequence 3, for example. So the magistrate will write on the paperwork, plea of guilty to sequence 1 and sequence 2 and 4, and withdraw sequence 1 and 3. So they're just the charges. They're the different charges under the one reference number. But you'll hear that a lot in the local court if you're interpreting in the local court. So that's what all of that means. So then we have bail applications. So police can give bail, but if police refuse bail, then you have to make the application in court. And bail is you're in the community under conditions. So you have to follow certain rules. And if you break the rules, then you can be charged by police for breaking the rules or breaching your bail. Bail is, you're not free. It's like conditional liberty, or your freedom has conditions to it. You can have your bail changed or varied. You can have your bail revoked by police, by the court, and police can arrest you and ask the court to detain you, revoke your bail, to cancel your bail. Bail is decided firstly by police, but if police refuse bail, then the court can give bail. The local court can give bail, or district court can give bail, or Supreme Court can give bail. Bail is decided by various factors, and there is a piece of legislation called the Bail Act, and it's can be quite a complicated process. There's this thing called show cause or show cause offence, and the bail legislation has a series of types of offences which are called show cause. And for example, if somebody is on bail at the time that they are arrested for something new, or they're on parole, then it becomes a show cause offence. Or some charges, like, for example, murder is show cause. Basically what it means, it's harder to get bail if your offence comes under that category. So certain more serious types of offences are show cause, or not because of the offence itself, but because you're already on bail or on parole at the time and there's a new allegation. So then it is harder. You must show good reason why you should get bail on the new offence. Show cause. And there's no set reason, there's no set criteria. It's really, again, the choice or the discretion of the court. But there might be various factors which get you over the hurdle of show cause, but it's hard. Show cause is harder to get bail than if there is no obstacle. Section 74 is a special section that if you have already applied for bail on that charge and been refused, then you have to have a very good reason why you should be getting another chance to make the application. So there might have to be a change in circumstances, your health, somebody else's health, maybe a job has become available for the person, various circumstances have changed, maybe the prosecution have decided to withdraw a charge, and so now your situation has changed, but you can't, it's going to be very hard to satisfy the court that you should be given another chance to make the bail application if your circumstances have not changed. That's the section 74. So some people come to court for a second application for bail and they've got section 74, they've already made an application before and their show cause. So it's really hard to get bail in that situation. But if you pass those hurdles, then the court will look at what's called bail concerns. And there's 4 bail concerns. And this is part of the legislation. So it goes back to what is the Bail Act, the legislation. So is this person a risk to the community? Will they fail to appear in court? Is there a risk that they're going to fail to appear in court? So let's have a look at their criminal history. Have they failed to appear in court any time previously? If they have, then there's going to be a real concern that, well, maybe they'll fail to appear in court this time. So it makes it harder to get bail if they have a habit or a history of failing to appear in court. So you have to look at their criminal history. The risk to the community is have a look at the criminal history. Have they got a history of committing offences while on bail? Have they got a history of violence? Have they got a history of committing offences while on parole? Then there's a chance that the risk to the community may be higher than somebody that has no criminal history or no history of doing being accused of things, wrong things, when they're already on conditional liberty on bail. So you have to look at the criminal history to answer those questions. And other bail concerns, the risk to the community, the risk of failing to appear, the risk of committing a serious offence while on bail. Again, look at what they've done in the past. Is that going to be an indication of what they might do in the future? So they're bail concerns, and it's part of the legislation. If you can answer no to those questions, or there's no evidence of it happening in the past, then your argument for bail is strengthened. Can the court put conditions in place to reduce the risk of those things happening? And if the answer is yes, we're worried about those things, but conditions can be put in place to reduce the risk of a person failing to appear, or to reduce the risk of somebody interfering with prosecution witnesses, or reduce the risk of somebody committing an offence while on bail, then the court should give the person bail under conditions, such as some of the conditions might be a curfew. A curfew is, for example, cannot go out, cannot leave home at night time. Now, this shouldn't be a condition if the offence itself did not happen at night time. Like, if there's no risk of this person misbehaving at night time, then they shouldn't really have a curfew. But a curfew, for example, stay home from 8 o'clock at night till 6 o'clock in the morning. Some people have that curfew, and then police will go and check. They might turn up at home at 2 o'clock in the morning to see if the person is home. The condition may be to report to police. So you might have to report to police every day or 3 times a week. Live in a certain place, so you have to give police and the court an address that you will be living at. And then there'll be an investigation of who is living at that address. If people have a criminal record at that address, police may oppose bail to go to that address. So police can investigate what the address is. Believe it or not, some people give a fake address, a building that does not exist. So police want to check, is this address legitimate and real? Or the condition may be do not talk or associate with or contact certain people. Don't contact the victim, the alleged victim. Don't contact a co-accused. Don't contact prosecution witnesses. And if you make contact by phone or physical contact, then that will be a breach of bail. So that might be a condition. Another condition might be a surety. Surety is a person that either promises to lodge or deposit an amount of money at the court registry and risks forfeiting or losing that money if the person fails to stick to and comply with all of those bail conditions. Or a surety might be a person that promises if the person breaks the rules, then they will forfeit the amount of money agreed. So they don't yet have to deposit the money, but if the person does anything wrong when they're on bail, then the risk is they lose the money. So they have to have the money available. They have to show the court registry that the money is available to lose. It has to be their money, not somebody else's money. Some people offer a surety putting up the house, like property, and having a caveat placed on the mortgage or placed on the property, and there has to be documents about that done so that you can't easily sell the house with that caveat on it. That caveat comes up on the title deed of the house, so that's some people have a surety where the house is put up as offer if the person breaches bail. It's a very big risk, a very big commitment. So that's bail, or release application is the other word for bail, release applications. Now, when you go to the local court or the district court, so in the local court you have magistrate, and they have the black cloak but no wig, and they'll be sitting at the front, at the top, higher than other people, in the chair at the back or the front of the court. You have a judge in the district court who does wear a wig, optional, most of them do, or justice of the Supreme Court. And local courts and district courts can also have registrars, and registrar may or may not be a lawyer. Some are and some are not. They're involved in listing matters in court, so that they work in the office, the administrative side of it, and they may also deal with return of subpoena, which we'll talk about subpoenas later, but they might also give orders about production of documents and dealing with applications for subpoenas. So they might also adjourn some matters which there is no argument about adjourning. So they might assist the court, assist the magistrate or judge by doing some administrative tasks on certain matters which there is no legal argument required for. You'll have lawyers in court, and in the local court you won't know which is the barrister or the solicitor because no robes or wigs are worn by the lawyers in the local court. So the barristers will just have their suits on. They won't be having the robes and wigs that they wear in the district court or the Supreme Court. You have, in the local court, you have police prosecutors, and they'll be in a suit at one side of the bar table, and you might also have a prosecution solicitor with a pile of documents as well. So you might have a prosecution solicitor and a police prosecutor in the local court sitting at one end of the bar table, both with a lot of files. And you'll have your defence lawyers at the other end of the bar table. You may have barristers can be junior counsel, senior counsel, or Queen's counsel, and senior counsel and Queen's counsel are the same thing. When there was a King of England, it would have been King's counsel. They apply to become senior counsel or Queen's counsel, and it's voted by other judges, by other barristers. It's voted, so they make an application and they have referee reports, and it's voted by other barristers whether this person should be made senior counsel or Queen's counsel. And every year, a list in about September or October, a list of new senior counsel is published in all sorts of law, civil law, corporate law, criminal law. And but you get many junior barristers that have been a barrister for 20, 30 years, and they haven't applied for senior counsel, for silk or senior counsel. The jury will be in the district court or the Supreme Court, and you'll have a space for 12 jurors, called the jury box, and that's where the jury sit on one side of the court opposite the accused person. So common words that we have in court are prosecution. So they are representing the community, and there may be a solicitor or a barrister or both, and they're usually referred to as Crown, Mr. Crown or Madam Crown. And so their surname, their family name is not used. The jury only hear them called Mr. Crown or Madam Crown, and they represent the community and bring the charges or the allegations against the accused person. The defence, likewise, may have a solicitor, a barrister, or both. The defendant is the person who is defending the charges. That is the person that is accused of something. They are the defendant. Evidence in chief is when a witness, whether it's a prosecution witness or a defence witness, gives their side of the story or evidence about what they heard, what they saw, what they did, what they saw somebody else do. That's their evidence in chief. They give a version, they answer some questions, and then they can be cross-examined. The accused can also give evidence in chief and be cross-examined. The complainant or the victim can also give evidence in chief, answering questions, what happened, what did you do next, answering all those questions, and then they are cross-examined by the lawyer for the other side. So evidence in chief is usually, you start off your side of the story, answering questions, and then it is tested in cross-examination by the opponent's lawyer. When something is fixed for mention, is just a new date is given, or a date is given for the matter to be briefly mentioned. It's a short appearance in court, and it might just be the court is just going to check in a few weeks what has happened in the case, what is the progress of the case. Have the documents been served yet? Have the parties exchanged reports? Have the police sent a copy of the brief of evidence to the prosecution and defence? So that's a mention. It's really just an administrative appearance in court, just checking what stage we're up to, what is going to happen next. So if something is fixed for mention, the court gives the court case a new date, and at a mention, the lawyers appear in court to explain to the court what has been happening and what they expect to happen next. And a hearing or a trial, so you can have a hearing in the local court, being a defended hearing. Somebody's pled not guilty in the local court, and you're going to have witnesses for prosecution and witnesses for defence come to court, give evidence in chief, be cross-examined, and then the magistrate will decide guilty or not guilty. Or you might have a trial in the district court or Supreme Court because somebody's pled not guilty and been sent for trial, committed for trial in the higher court, and the jury, 12 people on the jury, listen to the evidence. So prosecution and defence witnesses come to court, they give evidence in chief, they're cross-examined, and then the jury decides guilty or not guilty. A special fixture is something that is given a fixed date. It will happen on this date. There might be 4 days or 3 days set aside for this particular matter. It might be quite a complicated matter, and it's expected that it will take that time, and it will be given priority, be given allocated a judge or a magistrate if it's local court specifically for that period of time for the case to proceed. Because often, you go to court and you might have 5 other cases in the list and you're not sure what time you're going to start, not sure whether you're going to be first, second, third or fourth for that day, and that, yeah, there's uncertainty whether you'll start, whether you will finish that day, but a special fixture is given a definite allocation of a judicial officer, which is the magistrate or the judge, and the witnesses will all be brought to court on that date. Experts might have to come to court to give evidence, and it will be heard specifically on those dates. That's a special fixture. A committal hearing happens in the local court, and that might be cross-examining specific witness about a specific topic. For example, identification might be an issue in the case. Witnesses will have given statements to police, and there might be some uncertainty about who did the crime. Your client has been charged with the crime, but there might be some confusion or some different versions of what was seen or what was heard, and the lawyers for defence and prosecution might want to have just those couple of witnesses cross-examined, asked a few questions to clarify the details of their evidence, of what they saw or heard. And so it's not the same as the full trial later, but it's just to really clarify some specific issues. But you have to make an application to have that done. In most cases, it will not happen in, but some cases there might be an issue which you would rather know the answer before you go to trial. And sometimes the answer helps the prosecution decide, oh, yeah, this is not a strong case and maybe we should not be prosecuting this person. Or sometimes it helps the defence realise, well, okay, that witness clarified the point, they're quite a strong witness, and maybe the client might need to consider pleading guilty. That might be the situation. It's really about clarifying evidence, and again, it won't happen in every case. In fact, most cases, you will not make an application to cross-examine witnesses while you're in the local court before you get to the district or Supreme Court for trial. And whatever is said at that committal hearing, if the matter does proceed to trial, is evidence and will be used again. And if the person changes their story 6 months or 1 year down the track in the higher court, then what they said in the local court can be brought to their attention. Call over is usually in the district or Supreme Court, and it's like a mention, and it's really the judges are checking whether you are ready to go to trial, that everything has been done, that all your documents are ready, your witnesses are ready, there's no pre-trial problems. It's really just checking that everything is in place, or checking if there needs to be any pre-trial legal arguments. So it's really just mentioning the matter and checking that everything is ready. Usually the trial might be next week, and just checking that everything's in place. An interim order or interim hearing, very often this will be in relation to AVOs, and there will be a slide about that a bit later, but it's like a temporary order or a temporary order in place until the final decision about that issue is made. Or there might be an interim hearing or interim in the meantime, interim. So it's not permanent yet, it's not final yet. There's a court case still going on. The court case hasn't been finalised, but while we're waiting for all of that to happen, there's some temporary orders in place. or might be some protections in place, or an interim hearing might be about perhaps civil law has these a lot, an interim hearing to just have some temporary restrictions in place, put in place. There might be some legal argument about that just before any final decision is made in the actual case, just have some temporary issues dealt with, some temporary orders applied for or made. An adjournment is an application. Lawyers can apply for an adjournment. Something may not be ready. Maybe the adjournment is because some documents have not been made available yet. You might be waiting on a specialist expert report, and so you're not ready to proceed with the case. So you're seeking an adjournment of the case, a delay. An adjournment is like a delay. You're asking the court to cancel today's hearing and give you a new date. Or an adjournment will also happen when you mention a matter. The court is just checking what's been happening, and then it will be adjourned to a new date. So the mention might be, you tell the court that the police have now served the documents that you've been waiting for, and then the matter will be adjourned to give the lawyers a chance to read the documents and for the client to consider their plea, what they want to do about the charge. So the matter will be adjourned to a next court date for you to tell the court what you're doing with the case. That's an adjournment, and that might take 2 minutes in court, or it might take a bit longer if there's a dispute or an argument. Stay or stay of proceedings is like stopping something, either temporarily or permanently. A stay of proceedings is very hard to achieve in law. It has to be in the interest of justice, and there has to be usually a lot of good reasons, a lot of evidence why the case should be stayed, stopped, paused temporarily or permanently. One reason that an application may happen is the person has run out of money. They're not eligible for legal aid, maybe because they're on the means test because they're working, but they can't afford a private lawyer. So they might want to temporarily stay the matter until they have had a chance to find a new lawyer or find income and money to be able to pay for the legal fees. Or it might be because somebody is really sick and perhaps not going to get better. It might be a terminal illness or dementia, where the mental and cognitive ability of the person is going to deteriorate, not get better. And so there may be an application to stay the proceedings, permanently stay the proceedings based on the person's ill health. So but that application has to be made in front of the court. And if that happens, if it's stayed, then the proceedings are they're not withdrawn, but they don't go ahead anymore. And so that's that. And again, very hard to achieve. Forfeiture application will usually happen, the prosecution will usually make an application for property or money to be forfeited. And that will usually happen if there's a crime being committed, for example, drug supply. And there will be an application made for forfeiture of money related to the drug supply, or forfeiture of property obtained as a result of criminal activity, and or cars might be forfeited, houses might be forfeited, things like that. Similar, the confiscation order. confiscation of money, confiscation of proceeds of crime, and also drugs can be seized. The actual drug itself is seized and forfeited and destroyed. So those sorts of applications are made by the prosecution. Sometimes they might be opposed by the defence, but often you're not going to win an application to against forfeiting money which is said to have been the result of selling drugs or something like that. Jurisdiction can have several meanings. The jurisdiction can be, for example, the state of New South Wales. If a crime happens in New South Wales, then New South Wales is the jurisdiction. You can't prosecute it, a state matter in Queensland, if it happened in New South Wales. Federal matters happen, Commonwealth matters happen around Australia, but usually if the importation of drugs happened into Sydney Airport, then usually the prosecution will be in New South Wales. The Commonwealth prosecution will still be in New South Wales. Where that sort of change was with years back, we had, well, we still do, but people smuggling matters, where people, the staff or people bringing the boats into Australia with refugees and asylum seekers, a lot of people that were on the boat, driving the boat, were prosecuted, and they might have landed in Christmas Island or WA, but then they were prosecuted. The prosecutions were happening in Queensland, New South Wales, Victoria, all around the country, even though the boat did not actually arrive in New South Wales. But federal prosecutions can happen around the country. Jurisdiction may also be about the actual court. So is this local court jurisdiction? Is this district court jurisdiction? Who has the power to make the decision? Who has the power or the jurisdiction to hear this case? So which level of court? And if there's a jurisdictional error, that if the magistrate or the judge did not actually have the power to hear that matter, then any decision that was made would be invalid, and it would have to be dealt with in the correct court, the correct jurisdiction, for example. And judicial error is judge or magistrate makes a mistake, and it happens, you know, and it has to be corrected. And an example of this was for me on a Friday afternoon. I was in court for a sentence. Client pled guilty and was getting the penalty, and the judge, I was listening to what dates the judge was giving us and when the commencement date for the sentence was. So how much time had my client spent in jail waiting for sentence and when to start. And I was listening to it and I'm thinking, I don't think the numbers are making sense, that the date, the time he has served, and then the date that the judge has backdated to start the sentence, I don't think it's enough. But then you're wondering, oh, am I wrong, or is the judge wrong? Has the judge made a mistake, or have I misheard something? So at the end, I just asked the judge, can I clarify that, because I think there's been a mistake on the commencement date. I don't think you've given him enough credit for the time that he's served. I think the commencement date has to be further back. And the judge, he looked at it, and thankfully I was not wrong. Thankfully I was correct, but he had to fix it. And lucky it got fixed immediately on that day. 10 minutes later, the judge went away, had a look at it, came back and fixed it. But if it didn't get fixed then we would have to apply to reopen the case, or some people take it to the Court of Criminal Appeal to fix it, which is a very slow and long process. So I'm just relieved that I heard the mistake immediately and we got it fixed immediately, but that was a judicial error, but it got fixed. Very nerve-wracking.
Thank you, Helen. I just note the time, it's 11 o'clock. So
Okay,
at that point, we may take our 5-minute break.
absolutely.
And when we come back, we'll start on words used in criminal law. So I'll just put that slide up so that it's ready for when people return. And I'll just ask the audience, go and take a break, and we'll meet back here at 11:05.
Thank you. See you all soon. Oh, sorry, you're on mute.
Excuse me, Helen. Welcome back.
That's right.
And hopefully our audience are back with us. So we'll start now with words used in criminal law.
Okay, so in the local court, you'll often hear the term summary offence, and that is for matters which stay in the local court and they're less serious, and some of them only have a fine as a maximum penalty. So that's what a summary offence is. And indictable, indictment and indicted, okay, those words. A matter which is an indictable crime, by definition, under the Crimes Act, is something that carries a maximum penalty of 2 years imprisonment or more. And an indictment is a piece of paper with the charges written on it. Essentially, that's what an indictment is. And if you are interpreting in the district court or Supreme Court, you will see, hopefully the lawyer will give you a copy of the indictment, which is a piece of paper with the charges that are read out to the accused person, and the accused person enters a plea of guilty or not guilty. That's the indictment, a piece of paper with the charges written on it. When somebody is indicted, in a sense, that piece of paper is filed with the court, the indictment, and they are brought to the higher court accused of those crimes. They're indicted on those charges. Arraignment is in the district court or the Supreme Court, and it is where the process where the indictment is read out to a person and they formally enter their plea of guilty or not guilty. And there's also the other plea of not criminally responsible due to the mental impairment or cognitive impairment. That's the arraignment process, the process of entering pleas when the indictment is read out to the person. And after the arraignment, then if they've pled not guilty, then a trial date will be given. They are also arraigned in front of the jury when their trial starts. So the jury formally hear the person arraigned, those charges are read out, and they formally say guilty or not guilty. And if somebody is acquitted, that means that they have been found not guilty after a trial. They've pled not guilty, they've gone to trial, all the evidence has been listened to, and the jury or the judge alone has acquitted them, have found them not guilty of the charge or charges. A penalty is a punishment. A penalty could be a fine, could be a community release order, could be an intensive correction order, could be prison. Those are penalties. Penalties can also be demerit points in a traffic driving offence. Remand, if somebody is arrested and refused bail by police and by the court, they are on remand. They're in jail, they're on remand. They're waiting for their case to be finalised in court. They're on remand. Or it can also be a verb. You can be remanded in custody. So kept in custody, bail refused, waiting for your court case to be finalised. So remand can be both a noun and a verb. Custody has several meanings. You can be in the custody of police at the police station. So when police arrest somebody, the person is not free to go. They're not free to leave. They are in police custody. So police are in charge of the person. They are not free to go. They're in police custody. Or you might be in the custody of corrective services. So somebody might be in prison on remand, waiting for their case to be finalised, and they're in custody, they're in prison. They might also be in custody serving their sentence. So they're in custody, they're in prison, they're in custody. And verdict is whether the person is found guilty or not criminally responsible due to a mental health or a cognitive impairment. That's the verdict. It's the decision that's made about the guilt of the accused, whether they're guilty or not guilty. That's the verdict. It's like the judgment of the jury, the jury's decision or the judge's decision about whether the prosecution have proved the case and whether the person's guilty or not guilty. A sentence is it's part of a punishment. So a sentence could be a fine, a sentence could be full-time prison, a sentence could be an intensive correction order, which is a prison sentence, but served in the community. It's a type of punishment or type of penalty. A prison sentence has two components. It can be the total sentence or the head sentence is comprised of the parole period and the non-parole period. So the non-parole period is the minimum time that somebody serves in custody or in jail. And that is usually 3/4 of the head sentence, 3/4 of the total sentence. So 3/4 must be served in jail, and then 1/4 on parole. There is a way to have that ratio or those fractions varied, so that it might be 60% or 60% in custody and 40% on parole, or 66% in custody, 33% on parole. There is a way to have that ratio varied, and I'll talk about that later, but that's special circumstances, asking the judge to find special circumstances so that the person spends less time in custody and more time on parole. If you are interpreting in a trial in the District Court or Supreme Court, you may hear of this term black direction. Black is the name of a court case, a previous court case, a previous trial, and this comes about when the jury tells the judge, we are stuck, we cannot come to an agreement about the verdict. Then the judge will give them a direction, will tell them that you must try harder, you must go away, listen to all of the jurors, listen to everybody's opinion, try to come to an agreement amongst all of you, and come back to court. If there's any other questions or you're still struggling to come to a unanimous decision, then let me know. But that's a black direction, so nothing to do with the colour. It's a person's name and it's a previous case, and it's something that the judge talks to the jury about trying to come to a unanimous decision after they've already told the judge they've got problems and they're not agreeing with each other. Hung jury is when the 12 people on the jury cannot reach unanimous verdict, and they cannot reach a majority verdict either. They are further divided than that. So it might be 10 versus 2, it might be 6 versus 6, 7 versus 5, various splits, but they cannot reach a unanimous or a majority verdict. And if that's the case, and they write the note to the judge, and the judge gives them the black direction and says, try harder, go away, talk, listen, try to come to a unanimous decision, and they still cannot, then the case may have to be stopped, the jury discharged, sent away, the case just stops without a result. And then the prosecution has to make a decision, well, do we start this again? And often they do, often be new jury, new judge, more delay, start again. They often will start again. And there've been a few high profile cases in the media where there's been hung jury and the person is going for second trial, third trial. So charge can be both a verb, to charge somebody, which is what police do, or a noun, you are facing a criminal charge. And so, yeah, both a verb and a noun. Form 1 offences, these can be both in the local court or the district court. So somebody has pled guilty to something, they've admitted perhaps a more serious charge, and you're asking the court to take into consideration another offence or other offences. They might be related to the main charge that you're pleading guilty to and going to be sentenced for, but you're asking the court to take them into account, but you are not given a separate sentence for those charges which are on the Form 1. And for example, it might be, you might have a break and enter. Somebody might have pled guilty to break and enter. And in that break and enter, break, enter and steal, they've stolen a wallet, somebody's wallet, and then they've gone and used the credit card from the wallet at various shops. And so there's some charges using that credit card, pretending to be the owner of the credit card. So you get a charge of obtain money by deception, something like that, or goods in custody. You might have something that you stole from the house, and that might be goods in custody. And you might have those charges placed on a Form 1 because they're related to the main charge of break, enter and steal. A backup charge is something that is a less serious charge to the more serious charge. For example, supply prohibited drugs, and police also charge you with possession of prohibited drugs. So a person might be caught with a bag of cocaine, and the police might charge them with both supplying the cocaine because it's over a certain quantity, and police are saying you couldn't possibly be using that much cocaine for yourself. So we're charging with deemed supply. We're assuming that you are going to supply that cocaine to other people. Haven't caught you doing that. We're just assuming that. But backup, charge you with possession. It's in your possession, it's in your control, and you're possessing that for the purpose of supply. So police might charge somebody with 2 charges of supply and possess. And a person might say, they might agree that they were in possession, but they might say, but I'm not guilty of supplying. I was never going to supply that cocaine. I was never going to sell that to anybody. That's mine. It's my personal use. I have a drug habit, and they'll plead guilty to possession, but not guilty to supplying. Or the prosecution might just agree, well, we think you were supplying, but all right, we will accept a plea of guilty to possession. So that's a backup charge. It's a less serious charge to the more serious charge. Sentence assessment report is a report which is obtained, ordered by the court. It gets sent straight to the court, and it is written by corrective services, a section of corrective services called community corrections. It's another word, the old parole officer, probation and parole. So these people, they'll interview the client, the accused person that has now pled guilty. They'll interview that person, talk to them about the offence. They will listen to what problems the person may have, for example, drug habit, alcohol habit. They'll listen to those problems. What does this person need in the community? Do they need to go and do some different courses, anger management, drug and alcohol rehabilitation, etc., etc.? And they will also write about the attitude of the person to the offence. Have they taken responsibility, or are they blaming their friends? Are they serious about trying to change the problems? So that report goes straight to the court, and it may also include an assessment for suitability for community service or home detention. Agreed facts is a document which is like a summary of the case, summary of the evidence. And if somebody is pleading guilty, then we try to work with the prosecution to agree on what the facts should be. So sometimes what the police write has some things which are either irrelevant or incorrect or not quite fair. So we try to delete some things and agree to other things. So agreed facts might be a few pages, and that is what the person will be sentenced on. The judge will not read 10 folders of material. The judge will just read that short document which summarises the 10 folders of material. It makes it quicker. It makes it the judge should only read the relevant things. And if we can agree on the facts, then it makes it much quicker and much simpler for everybody, rather than arguing about everything. The burden of proof is on the prosecution in a criminal trial. The burden of proof, or the obligation or the duty, is on the prosecution to prove the guilt of the accused. The accused person does not have to prove anything. They can remain silent. They have a right to silence. So that's the burden of proof. Who must prove something? Who must prove the ingredients or the elements of the offence? And that is, in criminal law, that is the prosecution. And the level of how they must prove it is beyond reasonable doubt. So if you are interpreting in a trial in the district court or Supreme Court, you will hear the judge tell the jury that the prosecution's obligation is to prove the guilt of the accused beyond a reasonable doubt. And if there's any reasonable doubt that maybe this person didn't do it, or doubt about whether the prosecution have proved it, then the jury will be told you should find the person not guilty. You should acquit them, should find them not guilty. So it's meant to be a very high standard, high hurdle, beyond a reasonable doubt. And what is reasonable is up to the jury. But they're also told that you shouldn't be, like, suspicion or really serious suspicion that the person did this isn't enough to equal, it does not equal beyond a reasonable doubt. So the judge will tell the jury that even suspicion does not equal proof beyond a reasonable doubt. It has to be much more than that. But they don't actually explain it more than that either. It doesn't actually get explained, which I think makes it very difficult. Balance of probabilities is usually in civil or AVOs, which are civil proceedings. So balance of probabilities, the prosecution or the person bringing the action, if it's not a criminal case, the balance of probabilities, the person must prove it on the balance of probabilities. Sort of, you've got a scale and it's more probable than not. Just, it's not as hard to prove on the balance of probabilities as it is to prove beyond a reasonable doubt. And where balance of probabilities comes in for criminal cases is if you are running a defence of the mental impairment or cognitive impairment, then the onus or the burden, the obligation is on the accused person to establish that there was this impairment at the time of the offence on the balance of probabilities. So it's a less difficult threshold, less difficult hurdle than beyond a reasonable doubt. Then objective seriousness is something that you will hear and need to interpret if you are interpreting in sentence proceedings in the local court, district court or Supreme Court. Objective seriousness is a comparison between this case that the court is listening to and other cases where the same charge has been considered. So, for example, armed robbery. The facts of this armed robbery might be the person had a knife, they threatened the newsagent with a knife, they inflicted violence on the person, they stole a lot of money, and there were 3 other people committing the robbery with them. That might be the facts of one case. Another armed robbery case might be the situation where the weapon was not a knife but a stick or a pole. There was one person committing the robbery and the amount taken was maybe $100, not as much as the first robbery that you heard about. And so between those 2 robberies, which one does the court think is more serious? The one where there was violence, the weapon was more serious, the amount stolen was more serious, and there were more people committing the robbery. So the facts of the case get compared. Where compared to all the other cases of this type, what is more serious? Is this one a more serious example or a less serious example? Look at the facts, look at all the surrounding circumstances. So that's objective seriousness. Then there's the concept of special circumstances, and I mentioned this just not long ago when I was talking about sentences. And I was talking about non-parole period and parole period and the percentages or the ratio. So normally the non-parole period of a prison sentence, meaning the minimum time that somebody must spend in jail, normally that is 3/4 or 75% of the total sentence. So you have non-parole period, and then you have supervision in the community on parole. Special circumstances will allow the judge to alter or change that ratio. So instead of a 75% non-parole period, maybe the judge will make it 66 2/3% or 50%. So the time in jail gets reduced and your time in the community on parole under supervision gets increased. And there might be various reasons why that gets made, and there's no set criteria in the law. It's up to the judge or the magistrate. It might be the mental health or physical health, the age, might be somebody's first time in custody, a very young, very old person. It might also be that the person has some issues like drug addiction, which they need help with when they get released, especially if there's not many courses available in jail. Then they might be able to have to do those courses in the community under supervision. So they need time to deal with those issues. They're just some examples of special circumstances. And COVID, the conditions in jail during the COVID pandemic have been extremely harsh and tough, and that might also be a reason to find special circumstances, because jails have been short-staffed, staff members sick, inmates have got COVID, isolated, locked in cells, sometimes 24 hours a day. People can't visit face-to-face because of the threat of COVID. All those situations make jail much harder than it used to be when COVID did not exist. So you can imagine the mental health suffers when the conditions are even worse. A precedent is a past example. Precedent cases, so you're looking at past cases where a decision has been made, past decisions with the same law, or precedent with maybe a similar set of facts, and you want the judge to look at what happened in the other case previously, and so you want a comparison, or you want the same decision, you want to contrast your case from something previously, but you're relying on past cases, that those are precedents. Common law and statute law. So common law, the Australian legal system developed from England, country of the Commonwealth. Australia borrowed the laws from England, and those laws started off as customs, traditions and customs, and a lot of those old traditions and customs, including trial by jury for hundreds of years, then got transported to Australia, Canada, US, various other countries in the Commonwealth. So we borrowed the English common law. It's traditions, it's customs, whereas statute law is laws made by politicians in Parliament. And so we have both sets. You have traditional, also have old cases running on common law, but then you also have man-made, human-made parliamentary laws. So statutes are laws made by politicians as opposed to unwritten laws, which are traditions and customs. There are many documents in law and many documents that we have to file which have to look a certain way. and each court can have a different rule about the way something has to look, which can be very frustrating. And affidavit is one such document. An affidavit is, I use these quite a lot in criminal law. I can make an affidavit, it's evidence. It is written evidence, numbered paragraphs, 1, 2, 3, 4, 5. I might attach some documents to support what I am saying, or I might help a client. I'll type and the client tells me what they want to say, draft an affidavit. It's evidence, it's facts, it's not legal argument. An affidavit might be, for example, person's personal situation. I might draft an affidavit based on somebody's personal situation, and then I might attach some documents to prove what I'm saying, like a medical document, something like that. So I might use an affidavit. Sometimes I use them for sentence proceedings where I'm not intending to call my client to give evidence, but the evidence will be in written form in an affidavit. It's affirmed or sworn. They're promising that it's the truth, and they sign it, and it's witnessed. And if there is no opposition to that, then that becomes evidence. An affidavit can also be used in family law as well, civil law, but it's a sworn or an affirmed statement that the person is saying this is the truth, and you can be prosecuted for false evidence. And the deponent is the person that is giving that evidence. The deponent is the person who is saying these facts, this is what happened, this is the truth. So if I make an affidavit, in my words, I'm the deponent, and if my client produces an affidavit, then my client is the deponent. The statutory declaration is a very similar thing. And we have these in everyday life. Passport, statutory declaration as part of the passport application. You have statutory declaration when you travel back into Australia and you have to fill out the customs declaration that you do or do not have plants and food and all those sorts of goods. That's a statutory declaration, and a false declaration can lead to a fine, prosecution. That's a statutory declaration. You're declaring that that's the truth. And short form stat dec, that's the short stat dec, statutory declaration. So again, a document that you are signing that this is the truth, and it can be prosecuted if it's false. So we use these in everyday life, sometimes without even realising it. A lot of our forms for government have a statutory declaration witnessed by a justice of the peace or a solicitor, and they're legal documents. Notice of motion is another document which is supported by an affidavit. So if I'm going to produce and file a notice of motion, I must have an affidavit supporting it. The notice of motion is a document which seeks orders from a court. For example, I'm asking the court to order that the trial date be changed, vacated and changed. And why am I asking for that? Well, my reasons will have to be in the affidavit that I produce. For example, I have received 1,000 pages of new documents from the prosecution. I need to have those documents translated for my client. I need to have an expert examine those documents and prepare a report, and I cannot do all of this before the trial starts. That might be, those are the reasons for the orders that I'm seeking. So I make an application for certain orders on the notice of motion, which is usually a one-page document with the orders listed, very short document, but my reasons for it are supported in an affidavit. I cannot just go to court with asking for orders. I must provide my reasons, and it should all be in writing with supporting evidence. A subpoena is another document which can be produced, can be lodged, filed in the local court, the district court, or the Supreme Court, or family court, any court. And it is stamped, it's registered and stamped by the court registry, and the court gives a date for the subpoena to be called upon. So the registry will give a court date, maybe 2 weeks' time, maybe 4 weeks' time, for the documents to be produced. So I might, for example, subpoena a hospital, or I might subpoena police, and I'm requesting on my document, on my subpoena, a list of documents that I want, police or hospital or ambulance, doctor, whoever. I'm asking for those documents that I have requested to be produced to the court on a certain date, by a certain date. Then the person that I serve that subpoena on can either tell the court that they object, that they challenge this, that they're not going to do it for whatever reason, or they're willing to produce some documents but not all, and there may have to be a legal argument about that. It's a court order though. The subpoena is a court order to produce documents or to bring somebody to court. So I might also subpoena a person, I might subpoena a witness, and the court orders that they attend court on a particular date. And if they refuse to attend court, then the person can be arrested. A warrant can be issued for their arrest. And police and DPP, the prosecution, will issue subpoenas as well. They will issue a subpoena for all the prosecution witnesses. Sometimes interpreters are subpoenaed to go to court. You might be, if you're the interpreter in the interview with police, sometimes the police or the prosecution will subpoena the interpreter that interpreted the interview to come to court, especially if there's an issue about the interpretation or translation of a document or something like that. Then you might receive a subpoena to attend court, and there can be a warrant issued for somebody's arrest if they if they don't come to court. You should, as a person that's subpoenaed, there is money, conduct money. You're meant to be given enough money to cover your day, meals, travel, that sort of thing. So that's also, conduct money is also meant to be paid. Oath or affirmation. You have an oath or an affirmation on the Statutory Declaration or the Affidavit. You swear that you swear a religious oath that it's the truth, or you affirm that it's the truth. And also when you are giving, you give an oath or an affirmation in court as the interpreter, you are sworn in, you give an oath or an affirmation to faithfully interpret the evidence, and witnesses are given an oath or an affirmation before they give evidence as well. So that's oath or affirmation. And if somebody has been found to have lied in court, then they can be charged with perjury. So then we move on to offences against the person. So the victim is a person, and this as opposed to property. So offences against the person include anything from common assault, which can be verbal threat or physical threat or both, and it's that's the lowest level of assault. So it usually won't be either there won't be any injury, or if there is, it will be very slight injury, physical injury I'm talking about. The mental injury might be quite different, but the common assault has the lowest maximum penalty of 2 years imprisonment, and then you go up to actual bodily harm. So assault occasioning actual bodily harm. Actual bodily harm could be anything from a scratch, a red mark, a bruise, a broken rib, which heals. Okay, so the levels of injury vary greatly. It's more serious than common assault, but less serious than grievous bodily harm. So actual bodily harm has a maximum penalty of 5 years imprisonment. Assault occasioning actual bodily harm, 5 years imprisonment. Grievous bodily harm in law means really serious injury. Grievous bodily harm could be anything from a type of wound, stab wound. It could be permanent injury resulting in surgery, like a broken jaw, where you need surgical intervention, metal plates, that sort of thing. Offences that result in grievous bodily harm might be are punishable by much more. They might be recklessly causing grievous bodily harm, or they might be intentionally causing grievous bodily harm. They're both two different crimes, and intentionally inflicting grievous bodily harm is 25-year maximum penalty, so much more serious penalty for that serious injury, and intending to do it is much worse than being reckless. So there's different crimes against the person with different levels of penalties. A fray it's like, it can be a fight, can be verbal, can be physical, can be 2 people or more involved in an affray, and there doesn't have to be anybody witnessing it in the public, but it has to have, the behaviour has to have the potential of causing a reasonable person in the public to have some fear. Usually it's 2 or more, or a group of people. There's no actual crime called a brawl, but that's often what an affray is. So like a brawl, a street brawl, or some sort of fight. Sometimes affrays are organised as well. People organise to have a public fight with each other, and unfortunately some people bring weapons, and some serious injuries can happen as a result of the affray. But the affray does not have to cause anybody injury either. Sexual offences are also offences against the person. They're very serious, and the law for sexual assault has changed so many times over the years, and we still have prosecutions of sexual offences. The allegations, some of them, I've got some at the moment that are 50 years old, like really old allegations, and others are new allegations this year. So there's a very broad range, and a broad range of types of offending, and broad range of penalties. It used to be called rape, but now it's called sexual assault, and that is because the old language, rape, was really only covering the example of a male perpetrator or male accused and a female victim or female complainant. It did not cover examples of male victim and male perpetrator, or female perpetrator, female victim, female perpetrator, male victim. It didn't cover all the victims. The law did not protect all of the potential victims, and rape was really only about, because it only considered male and female, it really only covered male penile penetration of female vagina, penile vaginal penetration. That's what rape was in the past. So sexual assault covers many more acts of penetration. It includes somebody using their fingers, and I say someone because it can be male or female, using their fingers to penetrate the vagina or the anus of a female or a male victim. Some cases have where somebody has used an object to penetrate the victim. Sexual assault can also include oral penetration, like a male inserting the penis into somebody's mouth. That once there's penetration, it is sexual assault under the more modern laws of sexual assault. The penalties for various of those types of sexual assault may be different, because the penetration by the penis will be considered worse than penetration by a finger. But so the penalties will be different, but the charge will be the same, and the maximum penalty will be the same, but the actual penalty may be different. So the language has changed. The range of offending is much broader now than it used to be, and that's to protect more victims, to protect more people against those sorts of crimes. Sexual touching, again, the language has changed. It used to be, until about 2018, called indecent assault. So sexual touching is really touching somebody, male or female, touching a male or female on genital areas, breasts, penis, vagina, but not penetrating. Okay, so there's a distinction between the actual touching but not penetrating and actual penetration. So sexual touching can also be a kiss, an unwanted or non-consensual kiss. That can also be touching, but without the use of the tongues. Penetrating with the tongue is penetration, sexual assault. So there's some distinctions and differences. A sexual act may be towards somebody, so it might be an act of masturbation, might be a sexual act, or trying to get somebody else to do a sexual act while the offender watches or video records it. A sexual act might be an act of, for example, exposing oneself, exposing the genitals, or masturbating the genitals. That can be a sexual act. Sexual harassment is not a criminal charge, not a criminal offence, but it certainly is a workplace offence, for example. It can be a civil action and can be certainly relevant in the workplace sexual harassment laws and policies and all of that sort of thing. Child Protection Register. So when people are found guilty of offences, sexual offences against children, the certain offences may place them on a register where they have to register where they're living, what job they are doing. They may have to register internet usernames, passwords, email addresses, social media accounts, and police can check. And police can check their iPads, their iPhones, their devices to check whether they have used the internet. Some people are banned from using internet as well. And police can then check whether they have used internet. So some people on the Child Protection Register are not allowed to own a smartphone, not allowed to own a phone which is capable of accessing internet. And if they get caught, then they get charged and they go to court for breaching the rules. Consent is, so the laws have just changed about consent, just changed this year about consent. So consent is an agreement to participate or to have something done to somebody. Consent is an agreement. Consent cannot happen if somebody is asleep or drunk. So they can be drunk and they can be so drunk that somebody cannot consent. So intoxicated by drugs, prescription drugs as well, or alcohol, to the point where they're not capable of agreeing to certain activity. And some cases revolve around that. Was the person consenting? Did the accused person believe that the person was consenting? Why or how did they believe that? What was the conversation? What were the actions? How did they believe that? Is that reasonable to believe that? And that's what the jury has to listen to and make a decision about. Aggravated is a legal term. A sexual offence may be aggravated because there is more than one person committing the offence. So it might be aggravated in company, by being in company, one or two or more people. It might be aggravated because the complainant has a intellectual or cognitive impairment, so that might aggravate. It makes the offence more serious. The penalty will be higher. Or it might be aggravated because the person was intoxicated to the point where they could not consent, or it might be aggravated because of the young age of the person. Age of consent in New South Wales is 16. And historical sexual abuse, those are matters which are older than, like, for example, I have a case which the allegations are 50 years old. So that's historical sexual abuse. So that's that slide, and we'll have a break. We'll have a break now for a few minutes.
Yeah, thank you, Helen. It's just before 12, so we'll come back at 12:03. So take a break, everybody.
Perfect, thank you.
Welcome back, everybody. We'll get started again now with offences, property offences. Thanks, Helen.
Thanks, Bridget. Okay, so we dealt with people, offences against persons. Now, there's many offences when you look through the Crimes Act, Crimes Act 1900, which has been amended many times, but you'll see there's lots of offences that are relevant to the agricultural sector of farming as well, cattle theft, all of those. So it's quite interesting looking at what used to probably be even a bigger crime in those days, and now city people might think, oh, we never come across cattle theft, but of course it does still happen in those farming and agricultural areas. So there's a lot of property crimes listed in the Crimes Act 1900, which is quite fascinating. So property offences can be stealing from an individual, like snatching somebody's bag, stealing off the person literally, or it can be stealing from a home, can also be larceny. Larceny, these are all larcenies. Stealing from a store or a house, shoplifting from a store. Robbery has a threat or actual violence. So robbery the thefts don't have violence, but robbery does, an actual or verbal or both, either right before, at the time, or immediately after the stealing of the property. That's what a robbery is. So there's an element of violence, threat, or actual violence. Robbery in company is more than one person is committing the robbery. People can have different roles in robbery. Sometimes you have somebody that physically does the robbery, and somebody else might be looking out, making sure nobody else enters the store or the police are not coming, or you might have the getaway driver waiting in the car down the road. They can all be involved in the robbery, even though their participation or their roles is different, but they would all be, if they've all made that agreement to go in and rob somebody, they'll all be responsible despite having a different role in the robbery. And there's very serious maximum penalties for robberies. There's also armed robbery with a weapon of some description. Armed robbery has a higher penalty than, obviously, steal from person. But robbery in company and robbery in company can be the same maximum penalty as an armed robbery, but the judge might decide one is less serious than the other when actually giving the sentence, depending on all the facts. Break and enter or burglary. In New South Wales, we don't use burglary, but I think it may be an offence description in Queensland, maybe some other states as well. But we have break and enter. We also have aggravated break and enter, and when we're talking about sexual assault, talking about aggravated, but with break and enters, you can have aggravated break and enter, aggravated by knowing someone's home, and that's usually depending on the time of the day that it's done. Aggravated by using corporal violence, hitting somebody, violent to the person, or aggravated by detaining, keeping somebody captive, or aggravated by causing actual bodily harm. Then there's fraud. Fraud may include many types of fraud, forging somebody's signature. It may be fraud using a credit card and pretending that you are the owner of the credit card to purchase properties, either online or in person, so using a stolen credit card. Basically obtaining some property or money by pretending to be somebody else. That's the fraud. Hacking, well, that's very common and frightening and common nowadays, a big trend in hacking and identity theft, internet-based, online-based frauds and taking over somebody's identity and using remote access to computers and everything like that, and stealing money from people's bank accounts. It's rampant, and we're hearing more and more about it. People losing thousands of dollars from those types of thefts, often online, and can be very hard to police and to track and to bring people to court for that, especially when a lot of it happens from overseas, across jurisdictions. And I mentioned the obtain benefit by deception. So it's really getting something, whether it's money, property, you're committing a fraud, you're pretending to be somebody else, you're deceiving the victim into giving you something when you're not entitled to it. Obtaining money, obtaining benefit by deception. It can also be a Centrelink fraud, not telling Centrelink that you are working full time and still claiming a benefit. So that's also an obtained benefit by deception. Can be Commonwealth and can be state prosecutions of obtain benefit by deception. It can be a Commonwealth prosecution or it can be a state prosecution. Alcohol and drugs, very prominent in the community, and you, as an interpreter, you probably interpret a lot of cases where these issues come up, either because it's part of the charge, the criminal charge, or because it's part of the person's personal background and you're interpreting in a conference, or you are interpreting in court when, or a psychological assessment, and those issues are coming up for the person when they're talking about their life story. So illicit drug, for example, something's illegal, for example, cannabis, methamphetamine, also known as ice, ecstasy. So you've got the scientific names and you've got the street names. There are, of course, prescription drugs, which are a lot of the benzodiazepines, oxycodone, mental health medications, Largactil, different things which are prescribed by a doctor. They're not illegal, but they are illegal to have them without a prescription. And so you also have, I have a lot of clients who have addictions to prescription medication. They're taking too many and they're not prescribed, or they're buying them. They're buying them from somebody else who should not be selling them, and they're abusing them and they're addicted to those. So those, prescription drugs are not illegal, but it is illegal to have them without prescription. And possession of drugs, I touched on that. Person that in possession of drugs, some people are possessing them for personal use, and some people are possessing them for the purpose of supplying them to others. There is a penalty for possessing prohibited drugs, but very often the court will not give somebody jail for possessing the prohibited drug. They might be given a fine or some sort of be of good behaviour. So possession, there's different quantities allowed, or well, not allowed, but there's a threshold before it becomes considered too much to use for personal means, and before it becomes an accusation that you are supplying it. Supplying it, somebody might actually be selling the drug, but supply is also sharing a drug at a party, or sharing a drug in the home, giving somebody a drug which they haven't paid for, but giving it to them is also a supply of drugs. And deemed supply is when a person is in possession of a quantity of drugs which police allege is too much for that person to be using for personal use. You can successfully defend an allegation of supply if you give evidence that you are in possession for personal use, but it means telling the court you use this drug, how much you use, what your habit is, but it is a defence to deemed supply. The merit program is like in the local court where somebody admits their guilt to the charge and they are sent away to do a particular program dealing with their drug issues, like a rehabilitation, not residential rehab, but a program within the community dealing with the drug issues. And then once they've completed the program, they come back to court. If they've successfully completed the program, then there's a better chance that the court will not give them a jail sentence because they've shown change in behaviour and they've shown that they're willing to deal with the issue. There are charges for driving under the influence of drugs or alcohol, and there's different penalties depending on, for example, alcohol, the range of the intoxication. Is it low range, middle range, high range? If somebody is charged with high range prescribed concentration of alcohol, or PCA, then there is a higher chance of going to jail. If the person has done this more than once, the risk of going to jail is higher. If the driving conditions were difficult, like raining, heavy traffic, dark, you caused an accident while driving under the influence, then the risk of going to jail is higher. And there's also there's different penalties, fines, disqualifications, all of that sort of thing. These are done in the local court. These offences, these driving offences, are dealt with in the local court. Drug offences can be dealt with in both local and district court. The bigger the quantity, the bigger the chance that it is going to district court. And just to let you know, like large commercial quantity of supply of large commercial quantity of drugs carries life imprisonment. So it's very, very serious. Same with importing large commercial quantity of drugs, carries life imprisonment. So the penalties are huge. Unfortunately, there is a lot of domestic and family violence in the community, both charged by police and not. It's a big part of the job that I do. Legal Aid also has a unit that helps victims of domestic violence as well. And I also represent people as a defence solicitor. I represent people that are charged with domestic violence. And the domestic violence may remain in the local court, or it may be the violence may be so serious that it ends up in the district court. So domestic and family violence, they're two terms, the same: domestic violence, family violence. Domestic has a very broad definition, so it might be somebody, they may not be blood related, or they may not be married, but the people might be living in the same household. And it could also be people sharing a house, like students sharing a house. There's domestic violence between two people, violence between two people. That will be domestic violence, even though they're not related, but they're living together. So domestic has a broad definition. PINOP is P-I-N-O-P, person in need of protection. It's an acronym that stands for person in need of protection. And police can take out an apprehended domestic violence order against a person, and police then represent the PINOP, the person in need of protection, at court. The PINOP does not need their own lawyer if police have applied for the AVO, or apprehended violence order. If police do not take out an apprehended violence order, an individual can take it out themselves, go to the court and apply for one. Often, sadly, there's a lot of neighbourhood disputes where one neighbour will apply for an apprehended personal violence order against another neighbour, and people may have to go to a community justice centre to try to negotiate and to resolve the issue. But yeah, a lot of AVO, or apprehended violence orders, are taken out by neighbours, which is really sad and scary. So there's both. There's personal violence order between two people that are not in a domestic environment, not living together, or not related to somebody that's living with you. And there's ones that, so neighbours, workmates, somebody for some reason that is on, maybe attacked or harassed or stalked, by somebody that they don't know and that they don't live with. that might be relevant for an apprehended personal violence order. Consent without admission. So somebody, an accused person or the defendant in an AVO, whether it's apprehended domestic violence order or apprehended personal violence order, can consent or agree to the orders being made without admitting that they've done anything wrong. The courts encourage this a lot. Just consent to it. You're not admitting to it. It's not going to affect your not guilty plea. If you're pleading not guilty to the criminal charge, it doesn't mean you're admitting your guilt, but the order will be made for a period of time. Conditions will be put in place. Various conditions: do not assault, do not molest, harass, stalk, intimidate. Some conditions are do not go within 50 metres or 100 metres of the home or the workplace of the person. There's all different sorts of conditions. Maybe do not go near this person after consuming alcohol. That might be another condition. An AVO is not a criminal charge, but to break one of the rules is a criminal offence. So people can be charged for breaching or breaking the orders or conditions of the AVO, and then they have to go to court to be punished or maybe defend the allegation that they've broken the rules. And very often when there is an act of violence, one of those crimes against a person, police will also take out or apply for an AVO. And until the final order is made, the orders are temporary or interim. So you have an interim AVO. Provisional is when police first take it out. Then interim, the court makes the order temporarily until the next court date. And then it might still be temporary or interim until the final court date. And then if a final order is made, then that order is, for example, 2 years or 5 years. But while the case is progressing through court, if there's no consent without admissions, or not yet a final order, then the orders will be in place to protect the person, but they'll be in the interim or temporarily until there's a final order in place. People can defend these too. You can say, I'm not going to agree to this, and people can defend them, and then it's up to the court to decide, the local court to decide whether to make the order or not. And if a person has a criminal charge and they're found not guilty in the district court of the criminal charge, then they might come back to the local court and challenge the AVO, and they might win the AVO. The AVO is balance of probabilities. It's easier to the proof, the onus or the burden of proof is balance of probabilities in an AVO, because AVO is actually civil, not criminal proceedings. But if the person has won their criminal case, they've successfully been found not guilty of the criminal charge, they might say to the police, look, can you consider withdrawing the charge? It wasn't proven, withdraw the AVO. It wasn't proven in the district court that the person was guilty, so it's a really weak case. Can you withdraw it? So that can also happen, and that might be something that somebody might want to challenge the AVO. Sentencing discounts. Now, this is something that gets advised to clients in conference. So if you're interpreting in a conference, then you may be asked to, you hear the lawyer telling the client about discounts for pleading guilty, and also the courts will be talking about discounts on sentence when somebody's being sentenced. So the discount or the size of the discount depends on when did the person plead guilty. If they pled guilty in the local court, then they're eligible for a 25% discount off the length of the sentence. So if the sentence is 4 years jail, if the sentence was going to be 4 years jail and they're pleading guilty, and they pled guilty in the local court, then the court will take off 25%. 25% of 4 years jail is 3 years jail. So 1 year, quite a big difference. If, however, the person pleads not guilty when they're in the local court and goes up to the district court, which is called committed to the district court or Supreme Court for trial, then they change their mind and decide to plead guilty, they will only be eligible for a 10% discount off the sentence, providing they have pled guilty more than 2 weeks before the trial date. But if they've only pled guilty either on the day of the trial or less than 2 weeks before the trial, then they'll only be eligible for 5% discount off the sentence. So, you know, if you're going for that 4-year sentence, what would have been a 4-year sentence, the 25% discount is 1 year off. The 10% discount will be the 10% of the 48 months, the 4 years. So the 10% would only be not even 5 months, as opposed to 1 year for the 12 months or 1 year for the 25% discount, or only 5% of that 48 months if it's a very late plea of guilty. So there's a lot of encouragement and maybe pressure to plead guilty in the local court, but certainly people do have a right to trial, and I hate to see people that should perhaps defend their case be feeling a lot of pressure to plead guilty when really they do have a defence. But we have to advise clients of this. It is law. I have to, as a lawyer, advise clients of the discounts. Even if they're telling me they want to plead not guilty, I still have to tell them of their right to discounts. So yes, I have to go through this. So as an interpreter, you will hear those sorts of discounts being discussed in conference, and when the judge gives a sentence, they explain what discount they have applied to the sentence. Types of sentences. We have full-time prison is the worst sentence that you can get. And as I explained before, there's 2 parts. It is non-parole period, which is the minimum time in jail, or the parole period, which is supervision in the community. And if you can't get into any more trouble in that time while you're on parole, you have to go to meetings, perhaps go to courses, supervised for a period of time. A sentence of life imprisonment means life and you die in jail. So in New South Wales, a life sentence means life, the rest of your life in jail. It doesn't happen much, but there are people that are serving a life sentence in jail. The next worst sentence after full-time prison is an intensive correction order, which is, to be clear, it is a sentence of imprisonment. It is prison, but it is served in the community under supervision with conditions. So you have to be of good behaviour. You might have to go to the doctor and get treatment, psychiatrist or doctor, or you might have to go to residential rehabilitation as a condition. You might have to be subjected to drug and alcohol testing randomly. And if you fail the test, then you will be in breach. So there might be condition to not drink alcohol or not take drugs, things like that. So it's a set period of time that you are under supervision in the community, and that's an intensive correction order. If you If that gets cancelled, if you have done something wrong or you're not willing to be supervised, then that can be cancelled and you go straight back to jail. So for the rest of the sentence. So if you get a 2-year intensive correction order, the very most that you can get is 3 years. If there's more than one charge, the maximum is 3 years. So if you break the rules, then one of the consequences is you go back to jail for that time, for the rest of that time. Community correction order is not a jail sentence, but it is like promising to be of good behaviour. It does carry a conviction, so you're found guilty, you are convicted, it goes on the criminal record. It could affect the job in the future, but it's not jail. There are conditions, and again, it might be go and get treatment, always be good behaviour. You might have to be supervised by community corrections, go to these meetings, go to these courses. You may have to stop taking drugs or alcohol, various conditions. If you break the rules, you go back to court and face the consequences. You may get a worse sentence. So if you break that one, you go back to the court that gave it to you. Conditional release order, or CRO, is again not jail. It's meant to be, it's similar to the community correction order, but it's meant to be for less serious offences than the community correction order. But there's conditions. Some people can have no conviction recorded with this, provided they are of good behaviour for a period of time, and then there'll be no conviction. But you can also have these with a conviction, and again, be of good behaviour, follow certain conditions. The magistrate will give you certain conditions to follow. So that is meant to be for less serious offences than the other types of penalties. Fines, yes, the court can give somebody fines, and there's maximums. Different offences have different maximum fines. The court should take into account what you can actually afford, though, because if somebody has a lot of financial problems, or they're unemployed or on Centrelink benefits, it can be harder to pay the fine. So the fine should hopefully be realistic for the person. Because people can get their licenses suspended if they cannot pay fines. So the fines, if you don't pay the fines, it can be quite a consequence to other areas of your life, having that debt. Section 10(1)(a) this is from the sentencing legislation. So the Crime Sentencing Procedure Act, which has changed a lot over the years as well, as different penalties get designed by Parliament. The laws have changed. Section 10, subsection 1, subsection A is where the charge is dismissed and there's no criminal conviction. So you've done the crime, admitted doing the crime, but it's dismissed and no criminal conviction recorded. And that is usually if it's somebody's first offence, no criminal record, and it's not so serious. It's really hard to get that again. So once you've had that chance, it's hard to get that again. Section 10(A) is conviction, but with no other penalty, no fine, no good behaviour bond, just conviction with no other penalty. And so that's, no period of good behaviour, that's it, it's finished. Conviction, but no other penalty. I've touched on this before, but the full-time sentence is structured by having a period of imprisonment in prison, which is the non-parole period, and then serving part of your prison sentence in the community under supervision, and that's called parole. So you have a fraction, usually 3/4 in custody, in jail, non-parole period, 1/4 under supervision, on parole in the community. But if you can get a finding of special circumstances, for example, very old, very young, significant health issues, COVID, some judges will give you special circumstances because of the conditions being so tough at the moment with COVID. Those sorts of things. Sometimes a person's isolation because of no family in Australia, or they might be from an ethnic group where there's not many other people in the community or in jail speaking their language, and they're very isolated because of language difficulties. That might be a special circumstance. Psychological, psychiatric issues might be result in special circumstance and resulting in the sentence structure being changed. So you spend less time in jail, more time under supervision in the community. But if you breach the supervision, if you commit another offence or you don't go to all your appointments on parole, then parole board can send you back to jail. It can cancel your parole and send you back to jail for the length of that, the rest of the sentence, go back to jail and serve it in jail. So there's consequences for breaching, for breaking the rules. Mental health has also changed a lot. Last year, 2021, the new legislation came in, changing, expanding, broadening the mental health legislation. So it's now covering cognitive impairment as well, mental health and cognitive impairment or intellectual impairment. So some people, because of their mental health issues or their cognitive issues, intellectual issues, are not fit for trial because they don't understand the process. Even when the lawyer explains it to them, they're not really able to understand everything. They're not able to explain their side of the story because of their mental health issues or their cognitive issues. There's a set of questions which the expert, with a psychologist or a psychiatrist, will ask the person. And if they fail one of those questions, then they'll be considered unfit for trial. And then the judge will read the reports from the experts and decide whether the person is perhaps with some treatment able to become fit. Some people become fit on their medication. But with cognitive impairment, if the person's impairment is so severe, they may never become fit because there's no medication that can help them. But with mental health issues like schizophrenia or bipolar, some people with medication and time will become fit once they are better medicated. But the court, I should say, there's no advantage to being unfit. So there's this idea and the media, especially news and media, can misunderstand this. There's no advantage to being unfit. It's a terrible situation if somebody is unfit. There's no advantage to pretending, to faking it, because the consequences are really quite bad. And you get reviewed by the Mental Health Review Tribunal, and they send more psychiatrists or psychologists to assess you. There's a big delay in your case, waiting to see if you're going to become well or not. There's no advantage to all those delays. And if you are unfit and not going to become fit in 12 months' time, you come back to court. So the criminal charge does not go away, it just gets delayed. You come back to court for a special hearing, with a judge only, and then all the evidence is listened to. So witnesses come to court, prosecution, defence, experts about the mental health issues, and then the judge decides what to do with you. And people may be kept, if they're found to have done the action, then they'll probably be kept in jail and referred again to the tribunal to be monitored and treated, but they're not going to be released from jail that day. They'll just be kept in jail for longer, and it's not a good situation to be in. So again, there's no advantage. There's no, if anyone's thinking about faking it, I tell my client the consequences of these situations, because the media have the wrong idea that this is easy to fake and that people fake it and get off and get released from jail and never face the consequences of their actions. And that's not true. It's a really terrible situation. The Mental Health Review Tribunal will not release somebody into the community unless they are convinced, after many assessments, that the person is no longer a risk to the community or to themselves. So some people harm themselves, suicide attempts, or they harm others when they are unwell. But so the Mental Health Review Tribunal will not release somebody until it is convinced that the person is fit. And the tribunal listens to psychiatrists and psychologists. There's reports done looking at the treatment that the person is undergoing. So it's a very long process if somebody is mentally unwell, very, very long process. There can be community treatment orders, treatment plans put in place by a psychiatrist, and the community mental health team monitors the person's progress and whether they're taking their medication. So community treatment orders can be put in place. Some in the local court, you can have what was the old Section 32 or Section 33, which is now a different section of the new legislation, but the same idea. Not finding somebody guilty, but discharging the person under the mental health legislation on the condition that they go and get treatment. And if they don't go and get the treatment, then they get reported by their treating doctor and they come back to court and go through the criminal court process. So the defences, the old defence was called not guilty on the grounds of mental illness, but under the new legislation, it's act proven but not criminally responsible due to the mental health impairment or cognitive impairment. To be able to run this defence, you need to have expert opinion. The defence get an expert. If it's a mental illness, you'll get a psychiatrist. And if it's cognitive impairment, you'll have a psychologist or a neuropsychologist to do the full cognitive functioning tests. You may also have both experts because some people have two issues or more than one issue. They have a mental illness, example, schizophrenia, as well as a cognitive impairment. So I might need the psychiatrist to discuss the mental state at the time of the offence due to schizophrenia, for example. Did they know what they were doing was wrong? Did they understand what they were doing at the time? So the psychiatrist talks about the mental health, schizophrenia, but the psychologist will talk about the cognitive impairment. A person may have a mental illness but be fit. but they may have a mental impairment defence. So they might be fit and understand all the court, what's happening now, but at the time of the offence, they may have been so unwell that they did not know what they were doing or did not know that it was wrong to be doing that because of their mental health. But they're under medication, they may become well and they may become fit. So I do have clients that are fit now, but they really were very unwell at the time of the offence. Or you may have somebody that was both unwell at the time of the offence and can raise the impairment defence, whether it's mental impairment defence or cognitive impairment defence, but they are still unwell right now and they're not fit. So they've got two issues that the court needs to deal with. Their state of mind or their mental health at the time of the incident and their mental health now, their mental state, their fitness to go through the process now. They're two different issues and we get the expert to examine both issues. But we need an expert report, and once I have a report, I then give my report to the prosecution, who gets a separate, independent, neutral expert to look at the same issues, look at all the evidence, look at all the witness statements, how was this person behaving at the time, look at this person's medical history, how many times have they been in hospital, or this person may have been diagnosed with a cognitive impairment at age 3, have gone through special schools, they've always needed a carer, a support person, there's a well-established issue for this person. I get the expert reports, look at the whole life story. Some people are not diagnosed with a mental illness until they are older, and they may not even realise that they have a mental illness. They may be having some symptoms but not understand those symptoms, because to them the symptom or the idea or the delusion is very real at the time. And so they may be very sick when they've committed a crime, and only after they've committed the crime, when the lawyer thinks, hang on, there's something really not well with this person, I'm going to have this person assessed by a professional. I'm going to, there may or may not be past medical records. Maybe the person has never been to hospital. Maybe it's their first episode of psychosis, and that often happens around age 20, 21, 22. Person is getting older, they've got a lot of stress, they might be going to university for the first time, or there's something traumatic happens in their home life, or they're taking a lot of drugs as well, and this can also set off an episode. And it might be the first episode and they're undiagnosed, but only after committing the offence do they become diagnosed and then medically treated and given medication. So it's very serious, and the consequences of running one of these defences is also very, very serious. Okay, so often there's lots of American TV shows and movies and lots of words which we hear all the time, but which are not used in New South Wales law. We don't use misdemeanor. We don't have first or second degree murder. We have murder and we have manslaughter. So you'll hear those terms in American news and American shows, but we don't use those. Early release for good behaviour does not happen in New South Wales. With that non-parole period, that is the amount of time you must serve of your jail sentence. You don't get released earlier than that just because you're of good behaviour. If you are of bad behaviour though, it may affect your chance of being released on parole on the date that you should be released. So, but we do not have discounts for good behaviour. We don't get early release for good behaviour. But when somebody is coming up eligible for parole, the parole board does look at their behaviour in jail. And if they've been badly behaved, getting into lots of fights, using drugs, all of that, that will affect their chance of being released on parole. Plea bargain, we don't use this term, but we do negotiate. We do talk to the prosecution, we write submissions, we write representations, we do ask them to consider withdrawing a charge or perhaps prosecuting a less serious charge. That's what's meant by plea bargain, but we don't actually use that phrase in New South Wales. And that brings us to the end of today's talk. But before we finish, there are some publications and training which Bridget might wish to talk to you about.
Thanks so much, Helen, and thanks everybody for staying with us. I know that people find these webinars very helpful in their training or when they're refreshing their knowledge of legal terms. So thank you very much, Helen. Just to let people know that if you don't already subscribe to our Law for Community Worker series, that you can choose to subscribe by going to our website. And if you go to the Legal Aid website and look under workshops and webinars, you can look at a calendar to see what's coming up, but you can also subscribe and receive notification about upcoming webinars that may be of interest to you. And there are also publications on our website that you can order, and you can also download in electronic format. Also, just to let you know that we are going to be running this same webinar again on the 11th of October from 10 a.m. to 1 p.m. So if it's something that you would like to attend again, then feel free. We don't have any questions, Helen, but we have a few people saying thank you for this comprehensive webinar, so useful to the interpreters. So it's great to know that people are appreciating your time and explanations of all these complicated legal terms.
I just want to thank everybody, again, say that your role as interpreters and for those that also do translation of documents is so appreciated by us, and it's so necessary, because without interpreters and without people translating documents between languages, I can't do my job properly and communicate the legal ideas and advice to my clients. So I really do admire your work, and it's a difficult job, and I really appreciate it. So again, if some of you happen to see me at court, either in a case that you are interpreting in, or you just happen to see me at court, please do not be shy. Please come and say hello. And I hope to see some of you in some conferences in the future in the various languages.
If people don't have any questions, then we might just finish the webinar now.
Thanks, everybody. Bye, everybody.
Bye, everybody, and thank you.